What's going on, everybody? RDAPdan here, Federal Prison Time Consulting. And tonight we're going to be talking about a lot of the J6, the January 6th defendants who supposedly stormed the Capitol. And we have Tom Root with us tonight, who's going to comment a little bit on some of the programs we have to offer, how we can offer assistance. So I'd like to thank you, Tom. How are you doing tonight?
Just fine, Dan. How about you?
Doing great. Pulled Tom away from some lawn duty, so got to appreciate it. The wife gave him a break to hop on the computer here. So Tom, as I don't know, a lot of people, if you look at the defendant list on the January 6th on insurrections there, it's a very, very, very vast list. There's a lot of people that have either been sentenced that are still going through the process. There's some people that are incarcerated right now. And it's been kind of, I've been getting more and more inquiries as to what somebody might be able to do to better position themselves, especially if they're still in the early processes. Because if mistakenly, or correct me if I'm wrong, but all of this is going through DC, correct?
Yeah. To my knowledge, everything's being tried in district court in District of Columbia,
which is probably backing up the system quite a bit with, there's hundreds of defendants that are in this case.
Yeah, and it's not like DC was ever quick to begin with.
So with knowing that, and so some of the individuals that are incarcerated right now, they call them the J6 prisoners. Is that more likely because of what they did, the level of violence, the subordinates that was being presented at the time?
I'm not sure I understood that question, Dan.
There's a lot of individuals that got roped into this on that day, and they've been incarcerated the entire time. They've been
I have to tell you, I think it's a complete overreaction. Now, excuse me, I might as well be blunt. I don't have a lot of sympathy for the people who stormed the Capitol, but on the other hand, there was no reason those people should have been detained. I mean, there's no way, if you read the statute 3142, I believe, no way that those people met the requirements. They weren't likely to flee the country or disappear. And they certainly, I don't think, posed a danger to the community. I mean, they may have been wild that day, but, unless somebody came there with a long rap sheet, it made no sense. I just saw it as gratuitous political punishment, please the masses.
And, I still blame a lot of it on the fact that we had the Jenna Ryan case. She made such a spectacle out of it. And she was she had a very, very minor charge. She had a trespassing misdemeanor charge, but just kept putting herself in the spotlight, kept putting herself in the media, kept talking to the media against her attorney's advice. And nothing that came out of her mouth was articulated. Nothing was thought out, processed. It was just diarrhea of the mouthpiece. I think it kind of really put a lot of other individuals into a hot seat because of that. So, because I'm getting a lot of flack because I'm working with a lot of the J6 individuals. And it's not because I view the same views that they have, whether I did or whether I do or don't. The difference is I believe everybody's got an opportunity to take advantage of something, to show remorse, take accountability. It's not going to, somebody that went through this process that's going to try to go to trial. There's not really much that I or you could do for them. But for individuals that can see where they could have done some things a little bit differently, where, I share a lot of the same views as these individuals, but instead of showing up that day, I from my couch into my TV, I screamed at the top of my lungs, instead of making that trek down to the White House, to the Capitol. Bringing individuals through our program now on taking them through steps of accountability, because everybody, right now, I think it's becoming real to a lot of individuals, and there's a lot of very young individuals, a lot of young men that are in their mid to late 20s that went through this, that kind of just got kind of gung-ho, and they showed up and got in these heated arguments with the police, basically. And I think that's where a lot of these issues came. What do you think these individuals need to be doing right now? Because we are seeing a wide spectrum where people are getting probation, and then there's other individuals that are getting, a few years in prison. What do you think individuals could be doing right now that are going through this process that could position themselves for an outcome to either like a probated sentence or combination of probation and home confinement, or maybe a very like reduced prison sentence?
I think they ought to be planning their sentencing proceeding right now. I think they should be looking for people who can describe, well, I would say describe who they really are, provided who they really are was different than what the video showed on January 6th. But that was always my sense. These were just, these people from, average Americans, every walk of life, kind of people who would not throw a candy wrapper out the window when driving down the road because it's wrong, and got carried away in the heat of the moment. I would be doing my best to find people who could talk about what kind of folks they really are, and try to gather every good thing you ever did and line it up so you're ready to go and make the showing. I mean, I hate to say it, but I think one of the best things you can do is convince the judge that the behavior that day was completely at odds with the kind of person you are, and you're terribly sorry. And looking back on it, you're shocked you did such a thing. That's the kind of thing the judge wants to hear.
And with what you just said, so obviously the common sense is trying to get the judge to see that you're not this individual. Your entire life isn't based on this one moment of some poor irrational decisions, where I'm not going to say your decisions were irrational for going to a rally and protesting your rights, but where you allowed yourself to cross the line.
Yeah, and that's true. That at least starting out that day, everybody was doing what Americans are allowed to do. The ones that crossed the line got charged. And even if you don't think you crossed the line, but you're going to have to take the guilty plea, you better admit to the judge that you crossed the line, swallow real hard and, just fess up.
And I think that's where, our services can really kind of advocate in this situation, because what we've been able to do with so many defendants in the past is take all of those, what you said is kind of gather up every good thing that you've done and bring this in front of the judge. Problem is, you don't want to bring a trash bag of everything you did and just dump it out. It's got to be sorted, organized, alphabetized, and just determining what you're going to use. I don't think the judge doubts that a lot of these people are good people. I think the problem is a lot of these people that are going through this aren't taking it completely serious, and there's a spot in their mind where they're thinking to themselves, the judge is going to see that I didn't murder anybody, I didn't rape anybody, I'm not a bad person. That's going to come out in the end. And if that doesn't always come out, and if it does, I think trying to show to the judge that you truly are remorseful for what you have done, what you could have done differently, if you were given another opportunity. And I think being able to expel this in a narrative, reference letters, prepping for the PSR. I mean, how important is the PSR in the whole process of the dynamic from pre-sentence to going into the prison system? What if you had to explain to somebody the severity and importance on that, how would you explain that?
I would say that if you got a bookshelf with 3 books and you line them up in order of importance, it goes Bible, Constitution, PSR, and then everything else goes beyond that. The pre-sentence report will dog you for the rest of your days. If you ever cross the line again, it will dog you. Law enforcement will have a chance to get it. The problem is that the probation officer writes it. Probation officer works for the court, and you expect a certain amount of neutrality. Forget it. The probation officer is pretty much in the U.S. attorney's pocket. And when they recite the events of the day and the nature of the offense, they're going to take the United States attorney's description of it. They're going to assume the worst about every fact. I used to say that, if Mother Teresa faced sentencing, they would find something in there about how she used to sneak a little extra communion wine simply because everyone's bad. When you read the pre-sentence report that's prepared about you, if you're like everyone I've ever dealt with on this, you will not really recognize who that person is the PSR is describing. You've got a chance to try to correct the worst excesses in the pre-sentence report. The one thing I would tell people is when you object to something in the pre-sentence report, the judge has an obligation under the Federal Rules of Criminal Procedure and the sentencing guidelines to resolve the dispute, to either find that the PSR is right, which the judge finds 90% of the time, to find that you're right, or the judge can take the third option and say, well, that fact is not going to affect my sentencing, and just leave it. The problem is that a lot of what the judge says won't affect the sentencing will very much affect you if you go to the Bureau of Prisons. I have told people before that anything that could affect your security or custody level, your eligibility for RDAP, you got to fight it in front of the judge. And if the judge says, well, that's not going to affect the sentencing, you want your lawyer to say, with all due respect, Your Honor, it's very much going to affect how this sentence is carried out. Let's solve it.
We see that commonly with when gun charges are dropped, but they have the enhancement for sentencing purposes. A lot of times that's not argued properly, or I mean, in many cases, maybe it can't be argued, but defendants are completely unaware that that's going to cause them a problem later on down the road. With what you go ahead.
Yeah. You'll see it if someone ends up being a career criminal, so they have a higher guideline level. The 2 levels may be in there for the gun, and the judge says, well, that doesn't matter because I've got to use this higher number anyway. So if the 2-level enhancement isn't there, it doesn't affect the score. Well, yeah, it doesn't affect the score, but it affects a lot of other things.
Yeah. So when we're talking about this, and individuals aren't really prepped for their PSR, or their attorney says, yeah, we're going to work on that, we're going to get to that. It seems, I'm not going to say that it's been a rare thing that's been happening recently. It's kind of been since I've been doing this, is a lot of individuals aren't even aware they have a pre-sentence interview coming up until, in a good scenario, a week, to an average scenario, like a day or two. They're like, hey, I got to go do this thing tomorrow. They don't go in there prepared. They don't know what to bring with them. We try to have our clients organized and going in there kind of, with ball in hand, with your education in hand. If you've got a high school diploma, if you've got some college degrees, proof of that, these are all things that can affect you going to the prison system, but also the narrative. And because, I know what I was going to ask you when you said earlier that this is conducted by U.S. probation. This isn't necessarily the same probation officer that's dealing with them on pre-trial. This is a probation officer that is strictly in charge of doing the pre-sentence interviews, correct?
Yeah, definitely is not the one you're dealing with pre-trial. And it's someone who writes a lot of them and knows what he or she's looking for. And you score political points if you go in and you're organized and you've got education, you got diplomas, you've got other information. So the probation officer is not going to have to make calls and work on it. So frankly, the less they have to do, the more they like you.
And going in there prepared, I've seen on many of occasion where somebody has gone in so prepared that the recommendation from probation was a bit different from what the government was asking for. Sometimes it's in not in their favor. Sometimes probation's recommending higher guidelines. But also on the flip side, there's been many times when probation is offering a reduced sentence that they're going to make a recommendation. So I think is it fair to say the better prepared you are, the more likely that you're going to get a favorable recommendation from U.S. probation to the courts at sentencing?
That's very fair to say. And the judge is, I've always thought, and I couldn't quantify this, but I've always thought the judge is a little more likely to listen to the probation officer's recommendation for sentence than the government. I mean, the judge knows
even if it's an enhancement of time.
Yeah, unfortunately, even if it's an enhancement. And sometimes, Dan, you and I worked on the one where the government, the defense, and probation all said, give this guy 6 months of home confinement. The judge hammered the guy with 12 months anyway.
Yeah, it does happen.
That was not a J6 case, by the way. But, ultimately, you've got 694 federal judges, and there's no telling how one's going to rule. The guidelines have put a certain amount of structure into the whole procedure, but you still yeah, the more prepared you are, I mean, it's you're coming to crapshoot, but the more you know on how craps are played, the better off you're going to be.
To the YouTube comment user, says, Dan, I've been trying to contact you for weeks. Not sure which method you've been using, but here's a link right here, because I can't tell what your name is from the YouTube user. There's a link I just dropped in here. Click on that link. If you're not already in the system, use that. If you are in the system, feel free to shoot me a text, 509-434-4695. That's always the best way, guys, is if you're trying to get a hold of me, to try to use the consultation link. Just the text messages and the phone, it's blowing up constantly. But YouTube user, if you are an existing client or you're in our system, feel free to shoot me a text. I can pull up and see what's going on. So with the J6 and the media just all over this thing, like I just had an interview on the Business Insider over here. Let's pull this up here. And it was actually, I was real nervous to do the interview initially because it just seems like a lot of people have a very one-sided view of what happened. And the interview seemed to be a pretty non-biased, and it was just kind of spitting out the facts, which is great. But I don't think that defendants should be talking to the media. I have a lot of defendants that are like, we want to reach out to the media and, share our story. And I get it, because we think when we're going through this, that if I can just get this out in the media, they'll see that it's not what it is, and it can get turned around. How big of a mistake do you think it would be for some of these defendants to get in front of a camera and start talking? Or could that create the whole Jenna Ryan fiasco all over again?
Well, it would be hard for me to overstate what a mistake it would be. In virtually any federal offense, if you are the defendant, you're not going to get a favorable hearing from the media. It's got to be you better be a defendant in a political cause that's near and dear to the hearts of the media.
Right.
And that's not going to be J6 for sure, but virtually any, drug offense, white collar offense, I've
Doesn't
had
give much sympathy.
Yeah. I mean, frankly think Jenna is every defense attorney's dream of a poster child to say to their client, watch how this woman talked herself into jail.
She really did. I think she actually talked a lot of other people into jail as well. Because she made a massive spectacle out of something, because her crime, what she did, wasn't the end of the world. I mean, she trespassed. She had a misdemeanor. If she just could have sat there quietly, and she would have gotten a little probated sentence and been done. But she, kind of bastardized the whole thing. So now with a lot of the other defendants that I'm dealing with, because I've got a few defendants that are clients right now, and a handful of others that we're talking to on a regular basis, the mindset of them being able to get out of the funk that they're in. I've got a young man that I'm working with right now, and he's just finding himself kind of stuck in a rut where he's not able to be productive. Because you went through this phase, I went through this phase. What is some advice you would have for somebody, aside from what we can do to help them get a shorter sentence? How important is it to have a positive mind? I don't want to use the word positive, because it's hard to have a positive mindset when you're facing prison. But how important is it to have a productive mindset when you're going through the pretrial phases to position yourself to receive some sort of a favorable outcome? How would you be able to recalibrate yourself, knowing that you might be facing prison? What are some tools that you used?
Whoa, that's
deep.
I had a lot of those mornings when you just didn't want to get up. It's the kind of, you can't get it out of your mind. You start to think that 90 days, 6 months, 12 months is the end of the world. Who can see to the end of that long a period of time? The thing that helped me the most was defense attorney friend of mine telling me about this securities guy in New York City. And this was back in the 80s, how long ago it was. He got crosswise in some securities fraud and got 24 months. And when he got out, he came to see his lawyer and walked in and said, I got to tell you, federal prison saved my life. He said, I gave up smoking. I gave up drinking. I lost all this weight. I'm healthy. I'm happy. He said, this is wonderful. So I found myself thinking, well, it's not the end of the world now, is it? And it's of course dealing with people who are getting 240 months. You know,
Yeah, different
talked
different
to a
animal.
guy the other day who had a 470-month sentence, but he was something like 15 years into it, so he only had about 300 months left. Then that starts to put in perspective
It does.
that that this. And one thing you can do if you're thinking about the time, say this time next year, it'll all be over. If you're going to get a misdemeanor sentence, that might be, it might be 18 months, but it won't be that long.
A lot of people, you say, when you put it into perspective, unfortunately, a lot of people, that perspective doesn't hit for them until they're already there. When any potential, I mean, there's always mitigating you can do after the fact, but at this point where you haven't been sentenced yet, some cases you haven't even really entered a plea deal, that PSR hasn't been done yet. Doesn't feel to me, it's a fact that this is probably the most important time that an individual can try to find that lesson earlier instead of later. Because when you went through your situation, Tom, you didn't have a prison consultant, or did you? Or
Nope.
did they even exist?
It wasn't that long ago, but no,
you went to court on a horse and a buggy, didn't you? You're like,
I did not have one.
You didn't have one. So, and a lot of people didn't have one. I didn't have one, and they did exist when I went. But when I spoke to prison consultants, it was, if you didn't have 10, 15, 20 grand, the phone call abruptly would end, and they would leave you with this, like, too bad you can't hire us, because you're probably going to end up in a penitentiary where all these horrible things are going to happen to you. And, they just kind of drop the fear on you. At the very least, the clients that can't hire us, I think we leave them with, at least for the, the non-violent type of offenders, we leave them with some peace that, hey, the hardest part of what I believe almost all these individuals are going to go through is what they're going through right now. Not so much the prison sentence, but if they can get their mind focused right now on how important every little piece or every little play matters in this game of chess, that you really can create an ability. You want to give the judge a reason to want to think that you're somebody that deserves maybe a departed sentence or a probated sentence. And I hear it all the time, and I do believe it's true. I believe when most defendants walk into sentencing, to their day of sentencing, most judges are pretty much already kind of knowing what they're going to hand down. They've reviewed the PSR, they've reviewed the bullshit letters, and they're kind of prepared to hand the sentence. But then you'll hear these stories, and we'll call them success stories, where the judge will make an exact statement as, I was prepared to sentence you today to X, Y, and Z, but because of what you've presented yourself, and I truly believe that you are sorry for what you've done, that you have felt the consequences from this, that you have learned a lesson, because that's the whole point of sending some of these individuals to prison, is to teach them a lesson so they don't make these mistakes in the future. If we can help these defendants show up in court and really display to the court that they're not just signing some bullshit acceptance responsibility for a downward departure in the guideline range, if we can really get the court to believe that they're remorseful for what they've done, which takes time because there's actions that got to happen to do that. I am a avid believer, and we've got one of our clients in the room, Juan. Juan is a client who was looking at one point, a minimum mandatory of 5 years. He ended up getting time served one day, which the day he had to turn himself in to fingerprint and release. But then he did go F himself up later on while he was on probation and violated and ended up going back. But the point of the moral of the story, and Juan knows I'm telling the truth here, Juan can testify to, if you do things outside of the box and you don't just allow yourself to dwell in the negativity, you can make a difference in what type of sentence you might receive. You have to do something different from what everybody else has done that's going before you. And Tom, with your experience, you've got some of the best writing abilities that we've seen in the industry. We could pick anybody we want to write some of these letters, that somebody to do these motions. We use you because you're able to quote this stuff off the top of your head. You were an attorney, you went to federal prison, and now you're using kind of best of both worlds of how you combined it to advocate for these individuals. You hate getting compliments, I know, but it's the truth.
Something you said, Dan, and I thought of this earlier, and while it's on my mind, uh, I should say it. When you go in for the pre-sentence interview, you don't ever want to think that because you took a guilty plea and signed a plea agreement, you're going to get your 2 levels or 3 levels off for acceptance of responsibility. Those points, yeah, you've got them locked in, or you've got them, but not locked in, because they can go away at any moment. And I have seen defendants before and worked with defendants before who signed the plea agreement. Uh, Government agreed to go for the 3 levels. They go into the pre-sentence report and say, well, I didn't really do that, or no, that wasn't me. They'll minimize their involvement. They'll blame it on everything because they don't see themselves as guilty and they don't want to present themselves as guilty. And what happens is the probation officer then writes up the pre-sentence report and said, during defendant's interview, defendant denied responsibility. Therefore, I recommend no points off for acceptance. And I tell you, once that recommendation is made, it's really hard to convince the court to call that back. So just think of those 3 points as something you can have, but they're not vested. They're not vested until the judge says you get them.
And you can't have 1 foot in the water and 1 foot out. You got to, if you're gonna plead guilty, you've got to be all in. And that's probably
how many times do we see that though?
All the time.
Probation, or the pre-sentence report, where the defendant won't mention that, yeah, I was doing a line of coke every night, I was smoking pot, and you ask your client later, they don't lose points for it. Let's say it's a white collar crime, but you don't admit to substance abuse, and they'll say, well, I didn't want the guy to think badly of me. And you say,
yeah,
come on, man, you've already admitted to a felony. How much
the attorneys aren't like, why do you still think with all the content that's out there? I could see 5 years ago there was very little content out there on these topics, but now it's content heavy. Why do you think that the attorneys are still that, with what you just said? The attorneys are not educating them on that. And also the attorneys, when we do personal narratives, we want to submit them to probation during the pre-sentence interview, they're very almost against it. Do you think it's because they're afraid they're going to put something in their narratives that is going to offset and it's going to take away acceptance and points because maybe the attorney's not actually reading the narrative?
Yeah, it's a natural reaction for a lawyer to tell your client to shut up. Because the client speaks, the client gets in trouble. But yeah, you've got to, you've got to recognize your client's going to have to talk at some point, and you want to prepare them for how to do it rather than tell them not to.
So now when you're talking about Jenny, I'll answer your question in a minute. And Lisa Neely, hello to you as well. Talking back what you just said, Tom, when it comes to RDAP, I didn't want to, this video is not an RDAP video, but since we're talking about the pre-sentence interview, Tom, when you stated a lot of times the defendants don't mention their substance abuse or it's substance use. I think some people, when they hear substance abuse, they're like, well, I'm not sitting in a corner with a heroin needle in my arm every night, or, driving home drunk, slamming into trees. When they minimize this during the pre-sentence interview, it's a combination of not wanting to think poorly, but many defendants also tell me that they felt like if they talked about that they could get in trouble, because remember, some of these individuals are indicted a year ago, 2 years ago, and they're having their pre-sentence interview today, and their time frames blend together. So when probation starts asking them about, do you drink, do you use marijuana, cocaine, pills, they say no out of fear of what you just said, also out of thinking it can cause them to get in trouble, they can get remanded, it's going to cause for a harsher sentence. Why do you think that there's not more explanation from the counsel to the defendant on this topic? I mean, by this point, I imagine defense counsel has to know that if somebody could qualify for RDAP, it could knock some time off their sentence.
Oh, I wish that were true. Part of the problem is we're immersed in it. The defense attorney has largely done his or her job by the time you plead or they get to a jury verdict. And they're very good at that. They know the laws of evidence. They know, what pretrial objections to make and how to argue them. But once you've pled, or once you're convicted, sentencing, it's going to happen, guidelines. Guidelines are going to be what they are, and they just don't pay much attention. That's one problem. Second problem is that most people have CJA lawyers. You're lucky if you get a public defender from the Federal Public Defender's Office, because they're very good. And people look at me in amazement when I say that, but for many different offenses, I would rather have an FPD than go hire someone. But what happens to most people is they'll get a private lawyer who practices in that court, and part of the price of practicing in the court is every so often you have to take a CJA case. Only problem with CJA cases is you're going to get $6,000-8,000 for it. It's not enough to do it right. So they just can't be bothered to sit down to go to the pre-sentence report with a interview with the client, which is a good thing to have happen. And most lawyers, I should say some lawyers do, some just say, I go to it, don't worry, it'll be fine. And as Dan has explained, many times it's not fine.
How many times have you seen it where the attorneys don't even go, or they're not on the call during the pre-sentence interview?
More often than not. More often than not, they're absent. You're right.
And we also see with a lot of the CJA attorneys and private attorneys alike, when you have people that are hiring private attorneys, unless they're spending, $500,000 and up, but anything less than that, they're getting a private attorney or a CJA attorney that doesn't just specialize in fed cases. These attorneys, a lot of them do state and feds. So their focus is kind of melted and scattered and spread a little thin, where you've got a federal defender's office attorney. These guys, it's exactly, I was going to ask you, you kind of stole my thunder on that. I was going to say, CJA attorney, private attorney, or federal defender's office attorney, because it's the question, how many times you have a client that you talk to and they're like, yeah, I couldn't afford an attorney and this is why I got this sentence, or I'm going to fire this guy because, he's not making any money on this. So he's probably working for the feds. He's got it in for me. You hear that too quite a bit?
Oh yeah. I worked with a guy once who had gotten a white collar case, and he had something like 50 fraud counts against him. And it was a Ponzi scheme, and he was a bit player, but it doesn't matter because the bit players usually go down the hardest. And his lawyer negotiated a deal where he would plead guilty to one and all the others were dismissed. And this was one of the old pre-Enron fraud counts, maximum 5 years. Mm-hmm. Well, he went in to get sentenced. He got 5 years, and he was furious. He said that lawyer didn't even fight it. He didn't talk them down from 5 years. And I said, well, what happened? He showed me the whole deal. His guidelines were something like 45. They were up in the life without parole because so much money was involved. That happens in white collar. And his lawyer made the smartest deal he possibly could have made. And that was plead to one, you'll get the max on it, but it's only 5 years. He capped his sentence at 5 years. No way the guy would have gotten 5 years if he had pled to more than one count. And,
so it was a very good deal.
Oh yeah. I told him, you go find that lawyer and kiss him on the lips. That was perfect. But a lot of times they just don't understand how the deal
poor communication between counsel and defendants a lot, especially when you have somebody that's doing their pre-sentencing. They're in county the entire time, and they don't really have the ability to get out there and talk, because it's hard to get a hold of your attorney when you're sitting in county jail, at least at the level that you'd want to. So this question just came up, Jenny. You've got the perfect person to talk to right now, Tom Root. So 2-level gun enhancement, First Step Act credits. What is your take on that?
Okay. I'm going to assume we're talking about earned time credits where you take the programming to get your recidivism numbers down. Because, someone will ask me First Step Act and they'll say, well, we're talking about compassionate release, elderly offender, Section 404, just what? Here, I'm assuming we're talking about using that programming or that system where you take programs that address anger management, substance abuse, vocational training, and you can earn time credits that will reduce your sentence to up to a year. And once you've used that up, then you can get more home confinement. Yeah. If you want to know what is excluded, it's all in the statute. and there's nothing that is excluded that isn't in the statute. Fortunately, the 2-level gun enhancement does not disqualify you. If you get what we call a 924C, which is the mandatory 5-year additional for possessing a gun during a drug trafficking crime or crime of violence, then you got a problem. 924Cs are exempt, but the 2-point enhancement under the guidelines are not. We went through all sorts of problems with the Bureau of Prisons last winter when this started. I had a guy call me, he was all upset. See, he had like 99% of his drugs and marijuana, but one co-conspirator got caught with a little meth. So there was meth in his case, not much, but a little. And BOP said, you're ineligible. You have meth. Well, that's not what the rule said. What it said is if you have a methamphetamine offense and you got a 2-level enhancement for leader, organizer, supervisor, manager, then you're ineligible. So we immediately filed everything. We ended up getting the BOP to recognize that their case managers just weren't doing it right. But yeah, 2-level for guns, you're okay.
So question on that, Tom, what type of sentence do you think somebody would need to receive? Not so much the crime, but length of sentence. How much time would somebody need in order to benefit and get a full 12, in addition to the regular good time, to be able to get an additional 12 months of earned time credits?
Well, we have to make a few assumptions. We assume that most of our J6 people are going to go in as low recidivism risk or minimum recidivism risk because they don't have criminal records and they've all got high school diplomas or higher, so their numbers won't be very high. In that case, they can earn 15 days a month maximum. So if you're doing 20 days a month, you're going to get 10 days credit. What's it going to take? It's going to take probably 2.5 years for you to earn a year off. So I would say 30-month sentence. Problem is you have to work 30 months to get that 12 off. So maybe 38, 40 months.
So if we got the Jenny who just posted on there, she's looking at 60 months. Now, Jenny's case, she's got a 2-level enhancement, so she can't get RDAP. But in somebody that had a 60-month sentence that could also qualify for RDAP, I mean, the ability to really, really kind of chop this time up has really become a big opportunity for people now.
Oh yeah, she'll very easily earn that year off and probably earn some extra time beyond that. And if you have more than a year's worth of credits, you use that for extra home confinement or halfway house. Don't take halfway house if you get home confinement.
So, and Lisa, we'll get to your question here in a second. So on Jenny's case, Tom, just if I did some quick math here, so we take the 60 months times 0.85 brings us to 51. If she got 12 months for earned time credits, that'd bring us to 39. If she got a full year of halfway house minus 12, that could bring her to 27 months. Does that sound about right?
Yeah, by the time you get down to 27 months of time inside, you're going to have trouble earning that much, but getting that full extra year for halfway house or home confinement, because you're just going to run out of time.
Right.
But there are ways to, and I don't want to say game the system because that suggests you're doing something you shouldn't, but the way the BOP has the rules written now, you want to be taking one course at a time. Let's say anger management is called for, substance abuse, and you can still take non-residential, for example, the 40-hour drug course.
Right.
Get credit. In fact, you could take RDAP if they'll let you in, and RDAP will count as credit as well.
You just can't get right with the 2-level enhancement. You can still take RDAP. You just can't get the sentence reduction, but you can get the reduction for the FSA credits.
Yeah, let's say you take it's 9-month course in RDAP inside. Take 9 months in RDAP, you're going to get like 4.5 months off.
Yeah,
and that's a third of your year right there. But the secret is to have your case manager identify different needs that you have, and they go right in your program statement. Well, it needs anger management, parenting class, a whole list. And I mean, people who are wonderful parents still take parenting class. I've had guys get parenting credit they're not married, they don't have kids, but
Right.
doesn't
And
matter.
can't that circle back to PSR prep? Because if you really are prepping these, if we're prepping our clients properly for the PSR, anger management, gambling problems, a lot of these programs that may qualify, because we can see what the FSA availability courses, classes, what they are. So if we instruct them properly and find out they have issues with, say, anger management, we get that brought up in the PSR, that should be a shoe-in to have the case manager put that into their treatment plan, correct?
Yeah, a secret with the case managers is some of them are really diligent, some of them are lazy, but they all have a lot of people on their caseloads. And if you go in and sit down and say to them, my PSR identifies these problems, yeah, I'd like you to consider those as needs for programming, case manager is going to be pleased because they don't have to think, they just have to
Their
listen.
job for them, yeah.
Yeah, and it's in the PSR. So if anyone ever says, why'd you put that in? They can say, well, it's in the PSR. So yeah, it's a win-win. I've never found that arguing with a BOP employee was productive for anybody. But on the other hand, if you look at everything they're doing in the corrections area, from case manager to counselor, as how can I make their job easier for them, ends up almost always making your life easier too.
Yeah, makes sense. You don't want to go in there screaming and kicking and demanding. That usually doesn't get you very far in the case manager's office. Lisa Neely, one of our clients here, she's got a question here for you, Tom.
Yes.
Difference between departure and variance.
A variance is sort of like a junior departure. Departures require a much higher level of proof. There was a time before Booker, the Booker case in 2005, when the guidelines were mandatory. If you had guidelines 51 to 71 months, you had to be sentenced in that range. And the only way the judge could depart, and that's where departure comes from, depart from the range, would be to make very specific findings using very specific departures to go up or go down. And the extent of the departure, the bigger the departure, the more proof you needed. After Booker, the judges could go any place they wanted to, and just started calling those frolics a variance. I'm going to vary down, 2 levels. What made it a variance and not a departure? We were never exactly sure, except we all knew it didn't require that much. There was a case, just went back for resentencing. I want to say 8th Circuit, one of the states, 8th Circuit, where the guy just child pornography, but he was like a county commissioner or something like that, or whatever they have out there. And the judge sentenced him to probation and found all these reasons to depart downward.
That wasn't that long ago, right? This wasn't that long ago.
No, it wasn't long ago at all.
Yeah,
I read that in the last few months. And the government appealed, and the Court of Appeals sent it back. The judge resentenced him to the same probation. And it went back to the Court of Appeals, and they sent it back and assigned it to a different judge. And they, essentially said, hammer this guy. You're giving him a departure from his guidelines of something like 96 months, from 96 to 0.
Wow.
They called that a departure, and you needed a lot of proof. A variance, you don't. These days, we hardly ever talk about departures. We almost always talk about variance. And variance sounds more palatable to the judge, too. If you got a 33 to 41 month range, and your lawyer says, 27, vary down to 27, that'd be a variance. If your lawyer says, give her probation, then you're talking departure.
So in Lisa's question there, does she need to say anything to her attorney, or is this something her attorney should already be focused on for her?
Well, my belief is you should always say something to your attorney. And just say, are we going to ask for this? And if your lawyer says no, say, well, why not? If your lawyer says yeah, then say, okay, how can I help? But yes, always mention it to your lawyer. Never assume your lawyer is going to do something you've heard about. Now, many times your lawyer may say it can't be done, and here's why. And you should always listen to a reasonable explanation. But yeah, your job to ask.
And our job as consultants, a big role of what we do falls on attorney accountability, as well as we kind of provide the thought process and the questions to pose to your attorney to put you in a situation to where it's going to make you more educated on the situation, so you don't find something out later and go, why didn't my attorney do this? It's being dealt with now. And like what Tom just said, you can ask your attorney, and if he says no with an explanation, at least you know why. But how many times have we seen something where, I mean, we saw somebody file, I forgot which client it was. I remember you were like, oh my God, this is the worst sentencing memorandum I've ever seen. It was like a paragraph. It was like one page of like triple spaced lines that created a page of just one paragraph put together with some exhibits that was submitted 2 days prior to sentencing. Should defendants be asking their attorney saying, hey, can I see a copy of my sentencing memo before you submit it?
Oh yeah, and I think you should go beyond that and early on, or as you know, within 2 or 3 weeks of sentencing, say, well, what is your strategy for the sentencing memo? What can I provide to help you with it? And you know, get them thinking toward it, because many times I'll see a memo hasn't even been put in. You know, now it could be that there's good reason for that. That you've got a mandatory minimum. Got a guy who had an armed career criminal, a mandatory minimum 15 years. His guidelines were like 33 months. If it hadn't been for the ACCA enhancement, there was no sense messing around, because the judge had to give him 15 years. The judge wouldn't go over that, and the judge would have given him a lot less if he could have. If you happen to be unfortunate enough to be in that situation, try to get your lawyer to convince the judge to say, I'm not happy with this. I would sentence the defendant to a lot less if I were able to, because I've seen that come back later when people will get compassionate releases, or something opens up like the Fair Sentencing Act and the First Step Act, and courts will point to it.
Transcripts.
Discretion, but I see the sentencing judge said this guy should have gotten a lot less, so I feel comfortable doing it.
So with these J6 guys, for a lot of them, I would say, at least for the ones that I've spoken to, I'm going to say all of the ones that I've spoken to, first time nonviolent offenders, they have, there's an essence of violence on their case, because, I've got one guy that was holding a picket sign and the cops were pushing and he was pushing, and the sign, hit his hand and it turned into an assault charge. But these, for the most part, these are all first time offenders. All of the people that are in this situation, I think a lot of the January 6th defendants, most of them should be qualifying for the First Step Act, potentially RDAP. Even if they can't get the sentence reduction for RDAP, they can still get the sentence reduction for the FSA credits for RDAP, and that's what 4 months. Is that what we said?
Well, yeah. If you're a low or a minimum recidivist, right, you're going to be able to get 15 days for every 30 days of programming. So yeah.
Right. So we're talking 9-10 month class. So yeah, you're getting about 4 months off in addition to your good time, in addition to the mandatory halfway house. They have to give you 4 months when you take RDAP. So it's, even if you can't qualify for RDAP, there's still many things that you can do to kind of chop up the time. And then all the other credits that can be given, right? All these other First Step Act, the FSA earned time credits that can be given. Paying attention right now, knowing that you can't just show up to prison. You can't be a 22-year-old kid, go to prison who has no kids, and go take a parenting class because you decide to. That's what, Tom, you were alluding to earlier. So it's really important right now to understand what programs are out there once you get to prison. So you have this stuff listed in the PSR now. Somebody made a comment on here earlier when you made the comment, Tom, of the 3 books on a shelf, the Bible, Constitution, and your PSR. They took a little offense to not everybody's religious. I think the moral of that story is, whether you're religious or not, pick your whatever book is important to you. The PSR is that important. That's the point. Maybe the PSR is the only book on your shelf in that case. But so many individuals don't know how imperative it is to be prepared for this pre-sentence interview. How many people have you seen that have graduated high school or have GEDs or even have some college, and they get to prison, but because they didn't show proof of that and their transcripts are so old where they can't just call up and get transcripts. They get thrown into a GED class for weeks and months. And meanwhile, they've got a master's degree in something. This can all be avoided by being better prepared for the pre-sent, and not having your GED on paper changes a lot of the ramifications on your points, doesn't it?
Yes, it does. And a lot you will not be, a lot of things you won't be allowed to do until you get your GED, and you'll get GED points eventually once you complete it on your pattern score and your recidivism, but it's not pleasant while you're getting there. I had to laugh when you said that because I knew a guy who had a PhD in math but didn't have the records, and he spent the first few weeks in GED. Once they got the records, he stayed in GED, but as an instructor.
I fell into that category as well because I was very unprepared when I did my pre-sentence interview and knew nothing about any of this stuff. Got to prison, could not get verification of any diplomas, had to go enroll in the GED class, and thank God that they had a GED test, because they only do testing. I forgot, it's every 90 days or something like that. They had a test coming up within like a few days after I'd gotten there. So they allowed me. So I tested and passed the GED. But if I hadn't done that, I would have had to sit through a class, and it would have caused issues for other programming. I couldn't have done a lot of the other classes that I wanted to do until, I think a lot of the ACE classes, you can't do that until you have your GED or some sort of a proof of a high school diploma. And I didn't have access to any of this stuff. I couldn't get it from the high school that I went. The transcripts were too old. So these are things that can be avoided if you kind of pull your head out of the sand right now. And like Tom said earlier, sure, there's really hard days where you do not want to get out of bed. But that's the point of hiring a team like ours, is because our job is not just to get you a shorter sentence. At least that's not what it should be. If you're hiring a consultant, part of the work that comes with it is the life coaching aspect of it, the kind of telling you what you need to hear, not what you want to hear. And sometimes some of it's tough love, because at the end of the day, sure, there's a lot that can be done that might be able to mitigate your sentence, but everything that can be done is going to be a requirement of what you're willing to do. So we can plan out this roadmap for you, but if you're just going to lay in bed and not do anything with it, A, you're going to waste your money on a consultant, and B, you're going to be very, very bitter once you get into the prison system.
Yep. You won't enjoy doing the time. Of course, no one does, but that does remind me that I will often hear from people, well, am I going to have to know how to protect myself? And these are guys going to camps, and I say, no, let me tell you, most of the people in camp want to do anything they can to avoid going someplace worse. Because camps are as good as it gets. They may not be great, but they're as good as it gets.
The cell phones, that's probably the number one lead. That and the TVs are probably the number one leading cause.
Yeah, and that's my advice to people is stay away from cell phones. They're nothing but trouble. And I'm seeing now probably 3 times every week, DOJ will be indicting some inmate for cell phone, because possession of a cell phone in the facility is a felony. And they don't charge most of the time. The guys just go to the hole, get shipped to a higher level joint, but sometimes they will pull that felony out, and you could so you can find yourself, as one BOP employee explained once, doing life on the installment plan.
Yeah, it's a nightmare.
Get more time, and you get more time, and it just keeps going.
And like we have we'll just call you Calm. We have Calm talking about people getting their transcripts before they go in. Sure, that if you're being proactive, you should have no problem getting your transcripts. The problem is once you get there and you find this out, how hard is it, Tom? How many people have you seen that are in, right? And they call their family members or their point of contact or their loved ones, getting them to do things for them in the free world. Sometimes to get somebody to do something for you when you're inside, it's almost like it goes by real slow. These people, it was very hard even for me, with having good support, to get them to go kind of act quickly and do things. That's why when we work with our clients, we're very, very clear when we talk to you before you go, who's going to be your point of contact. Don't just say, oh, my best friend or my brother. Like, is this person going to be there when something needs to get done? Because a lot of the time is of the essence, and there's so many mistakes. I spoke to I told you, Tom, there was a client that was reaching out to us that we had helped a while back ago do compassionate release, and she sent an email, and you told me that the court hasn't responded yet. I spoke to her today, and her issue that she thought she was having was when we sent the client the compassionate release to sign and sent to the court, he sent it certified. When she checks it online, it still shows that they haven't received it. She didn't know to go into Pacer and look in Pacer, but when I go in Pacer, they did get it. They did upload it, but there's always these missing links where if she didn't have somebody like us on the outside to deal with, they were just thinking the whole time that the court never got it in Puerto Rico. Meanwhile, it just never got updated somehow. It still shows that it's in transit, but it's in Pacer. So clearly they did get it. These are things that people aren't, the moving parts are so vast that if you think you have it all figured out before you go, the rug is going to get yanked underneath you so fast and so quick, and it leaves you high and dry and very angry.
The other problem with people on the outside doing things for you, many times you'll need something done and they're just not allowed to do it. They'll be they need the particular power of attorney form. I know, for example, in Ohio, power of attorney, your normal power of attorney form, no matter how detailed, can't sell a car with it. You have to do Bureau of Motor Vehicles own. It's a good idea to have all that in advance with as many POA forms signed as possible, especially because you get to prison. If you need a notary public, they can be hard to come by.
Yeah.
And I can't tell you, probably once a month I fight the battle of someone in prison, and they'll have the case manager certify it because they're allowed to under a section of the federal law. But some knucklehead down at the county courthouse won't accept it. And they'll say, well, I've never seen that before. It's constant battle.
Legal calls have become a big necessity, especially now with there's a lot of things that defendants, not that they can't say them on an open line, they're in this level of not knowing what they can or can't say, and they don't want to say what they can or can't say until they get on a legal call. And we've had to do that for quite a few defendants, quite a few of our clients, where we've had to do these legal calls with them so they could, talk openly, be able to express what it is. And some of these, like the one we spoke to recently, was a pretty important call. It was one that we probably couldn't have I wouldn't have wanted to discuss what he was discussing on a recorded line. So being able to have assets to your becking really can create situations for you that is going to, it's going to give you peace of mind because you're being able to make moves and get things done, but it's going to allow you to make decisions without fear of putting yourself at risk.
Yeah, all the calls are monitored. All the inmate calls are monitored and recorded. The fear that the BOP is going to turn it over to someone is probably overblown. If you read the policy statement, about the only thing they can do with it is give it to the U.S. attorney if there's an active criminal investigation going on. But that wouldn't give me the warm fuzzies. I wouldn't want to be saying things into that phone.
Yeah, not to mention you're sitting there. Maybe there's something you don't want other inmates to hear. It's not like you're in a phone booth where you close the door. You're sitting, next to the in and out doors of people are coming and going. You're next to other phones where if there's something that you need to talk about that you can't talk about in front of other inmates, for one, what's your next bet? Writing a letter and hoping they don't read the mail coming or going. But it's one more roadblock that can be dealt with by having a competent team with you, and if you take a halfway decent attorney, we go back to the attorneys that are the CJA attorneys. If you have a CJA attorney aligned with a prison consultant, I think that is going to enhance the work that the attorney is going to do, because how many times have we worked with the attorneys where we're taking a lot of load off of their plate. Instead of the attorney getting inundated with these questions that they really maybe not even knowing the answers to, about RDAP, about First Step Act, about additional halfway house, about what type of prison they're going to go to. We've got clients that should be going to camps, and the attorneys are asking for recommendations at sentencing to a prison that is not a camp. And in some cases, it's not even the right gender of a prison. They're asking for, a prison that's only for men or only for women, and not knowing the difference, which can have adverse effects down the road, because we know that the BOP has final decision of where you're going to go. But we also know that if you do make a recommendation, and it's an educated recommendation, it covers you could go there based on your custody level. It does have the programming needs that are met, and it's within some sort of a 500-mile radius. There is a better chance that you will go with the recommendation. But if you ask for a recommendation that's outside of your points, it's a complete waste of a recommendation.
Yeah, that's true. And as far as the CJA lawyers go, one of the big fears is always you're getting in their pockets because you're doing work that they can't bill for. But it's not an issue with CJA, because those guys make so little on it. Usually in the first 2 weeks, they've done enough billing to cover every dime they're going to get paid. And
Right.
so after that, any work you do for them just makes life simpler.
So to sum all of this up, Tom, if somebody out there right now is a J6 defendant, is there a benefit for them to reach out and talk to us on a consultation to find out what they might be able to do to serve a lesser sentence than what the guidelines are looking at, and potentially not go to prison at all?
Well, yeah, I don't want to, it sounds like enlightened self-interest, but having the consultation isn't going to hurt anybody. And yeah, you don't know. It may, the worst going to happen is you'll waste some time on the phone, but you may learn something you didn't know, and there may be something that really can be done.
And guys, the consultation is free. Really, the only thing you need to do is there's a link right here. Post it in here, and when you go to the when you go to our website, federalprisontime.com, you'll see a little button that says start here, and it's going to bring you right to this page. You're going to fill this information out. It's real basic. It's going to ask you some information, a little bit about your case, nothing too personal. And then after you follow all of these prompts and fill all this stuff out, it's going to bring you to our calendar. Click on that, book yourself a free 15, 20-minute call. We hop on there. If there's something that can be done, we'll talk about it. And at the very least, you're going to get some information similar to what we're going over today. But it's easier to narrow down, because when we're talking to you, it's going to be specifically about your needs. It's not going to be so broad as these videos are. So take advantage of the free consultation. We hope you become a client, but we've helped at this point. We've helped thousands of individuals. Not all of them are clients, but with the information that's posted, I get emails and text messages daily, as I'm sure you do, Tom, saying, "Hey, I've been watching your videos, I've been following your content. I did everything you said at sentencing, and I want to thank you because I was looking at this and I ended up getting this." And these are people I've never spoken to before. It's just like a thank you out of the blue. So posting this content out there, it's fulfilling for me, because I went through what you guys are going through, and I know how daunting it can be to wake up in the middle of the night and your phone rings on a Monday morning and you think, "Oh my God, this is it. It's coming. This is the end. I have to tell my kids." And everyone's telling me it's not a big deal. There's the roller coaster of emotions. It seems like nobody understands. You're embarrassed. You're ashamed. We have a community of like-minded individuals. We have a separate Facebook group that is a private group. It's a positive group. It's anybody that's in that group is somebody that's either gone through it, they're going through it, they've got a loved one that's in it. And you can learn from other people's mistakes and what they've done. And that's been our motto from day one, is communities, method, people up, and people one day at a time. Tom was a last minute bring on tonight. It was, but I figured, with the wisdom that he has with the First Step Act, because not everybody's going to qualify for RDAP, and in a lot of cases, based on the sentence, the First Step Act can replace what somebody would have gotten from RDAP alone. So definitely, guys, take your time with this. Don't sleep on it. Don't think your attorney is just going to do everything or it's magically going to go away. Have yourself a consultation. Have your loved one on the call with you. Make sure you're holding yourself accountable. And if there's something that we can do for you, great. If not, at least you'll know what you're going to be dealing with ahead of time and not finding out once you're already there. Any final words, Tom, you want to leave people with?
No, I think you pretty much covered the landscape.
Speaking of, I'll let you get back to yours and cutting that
Yeah,
grass.
yeah. There is one thing I'll mention, and I'll try to do it in 30 seconds or less, is that you as a defendant have a right to your pre-sentence report. You cannot take it to the facility with you because the BOP doesn't let you have your pre-sentence report inside. But get it, give it to your contact, give it to your loved one, have it available because someday you're going to need it for something. Even on down the road, I can't tell you how many guys I'll talk to and say, well, I don't know, whether I qualify. And I say, well, how'd your guidelines come out? They don't know. Where's your pre-sentence report? I don't have it. So that'd be my final suggestion. And that's free. Just tell your lawyer you're entitled to it and keep a copy.
Very good info. All right, guys. Well, there you go. I appreciate your time for coming on. Guys, I'm rdapdan, Federal Prison Time Consulting, People Up and People, Communities Method, one day at a time. Stay safe, everybody. Talk to you in a couple days. Peace.